Hey everybody, this is Andrew Lee, your admin over at the California Insurance Agents Group and CEO of Health Mutual Network. And I do have a guest with me here. Her name is Patricia, and she is actually a lawyer slash insurance agent slash a couple other designations. So we're gonna get into what she does, but I definitely wanted to get her on here because the legal side of what we do isn't really talked about too much. So I wanted to get her on so that we can explore those options. So Patricia, if you don't mind quickly introducing yourself to the audience and sort of what you do and why we're talking here, and what the significance of having legal knowledges would be, if you can get into that.
Yeah, no, absolutely. So my name is Patricia Pangelinan, and I have the worst last name on the planet. Got it. But I spent 14, 15 years as a insurance agent, and then legally blonde style decided, you know what? I guess I'll go to law school today. Went to law school, graduated, passed the bar, and now I act as I'm an associate attorney with a firm called Stone Dean Law, and we deal with a lot of effectively all things insurance. Everything from mergers and acquisitions, to employee, trade secrets where people, leave and they take their clients with them and everyone is mad. I kind of jokingly call them corporate divorces. They're corporate level divorces because everyone is mad about everything. Um, and we do a bit of regulatory, dealing with, you're a new agent or you want to say transition from working for someone else to working for yourself and you need assistance getting your licensure set up, getting everything set up, getting the business side of everything set up so that you can operate properly. And we also deal with a lot of, making sure that once that business is set up, that you're doing things again properly. So hiring, firing employees, dealing with all of the joyous California labor laws, which are significant. Um, and that's, kind of my background. When I was actively selling insurance, not that I ever really left the insurance industry. I just kind of transitioned to a different side of it. Um, but I dealt with all things. I was a farmer's agent and then I went independent, but I've done a little bit of everything. Dealt with a lot of commercial, a lot of personal lines, a lot of coverage issues over the years, a lot of, taking an insured who has effectively on paper, or at least first glance, no ability to be insured, and then figuring out how to actually get them insured.
Right.
And making sure that those contracts and coverages all match up. Um, and transitioned out of being before I left insurance I was a farmer's agent, so transitioned out of being a farmer's agent onto and then went into the legal side where we're touching all things insurance.
Right. Now, for the audience out there, let's say, well, anybody that's sole prop, that's starting off or an LLC, what's the biggest legal exposure for agents out there?
It kind of depends. So it ranges from, if you are just starting out, like if you're brand new to the insurance industry and decide, you know what, I just got my insurance license last week, I want to go sell things. I think the biggest exposure people face is they say overpromise and don't know what they're actually selling. So what they end up with is placing a client where they think they have coverage, and at the end of the day, the client doesn't have the coverage that they thought they bought, or at least interpreted that what they bought. So it's a combination of, I would say, miscommunication plus not placing the insured with the proper coverage, but on paper thinking that you did, or verbally saying, oh yeah, you have you're covered for everything. You have full coverage, everyone's favorite line. And the reality is that they don't. That's your kind of, I want to say, and newer agents are a little bit more susceptible to that, but even, huge, multinational brokerages get, hit with things in that realm. Okay.
Right.
So it's across the board. And the other part of it that I want to say newer agents are maybe a little bit worse about is making sure that they have systems and processes in place to document everything.
Gotcha.
So say you do tell your client you have full coverage for everything. You're covered for the universe. Or at least that's how they interpreted what you said. If you document, no, this is the policy they had, this is what I explained to them, and have processes in place, you have a little bit of a buffer in terms of defense if, things hit the fan, um, and you end up in litigation, having that backup of, well, I, as part of my agency's normal day-to-day process, when we call someone, we document it. When we send them an email, we document it. When we sell a policy, this is our normal standard procedure, and this is how we document it. And, having those types of things is critical to, and again, a lot of new agents either don't have the resources or don't have the expertise to know, well, what do I document? How much do I document? Do I document every single time I try to reach this person? Do I only document it when it's like critical? The reality is you need to document every single time you try to reach someone, every single time you call them, every single time you email them, document everything.
Right.
Um, because
Well,
now you have a paper trail.
yeah, let me ask you this. So, I mean, even a new agent will have an E&O
Mhm.
insurance. They will have E&O coverage. Most carriers do, at the very least on the health side, it could be pretty much across the board, at
Yep.
least 1 million worth of liabilities.
Mhm.
So, if that's already required by the carriers, and of course it'd be, in their good faith to get an E&O policy, even though it is pretty much a prerequisite for most carriers. What is the difference between legal services that you'll get from your E&O coverage? Like everything that you just mentioned right now, I mean, could fall under, an E&O claim, essentially. Where does hiring a lawyer, and now we're getting a little more advanced, where would hiring a lawyer come in, and what exposures outside of what an E&O coverage, just a standard E&O coverage could protect, what would be the best, I guess, indicator that you would need to hire a lawyer as opposed to just relying on your E&O coverage?
Well, so it's kind of I want to say it's one and the same, I think is the best way to put it. Okay. So like we as a firm, we end up being hired by the E&O carrier to defend the agent. So we have, a number of cases where there's E&O coverage. Okay. We submit that, we have a relationship with that insured, which is the broker, to the E&O carrier saying, look, we do this type of work. Okay.
Mhm.
They know us,
Okay.
they like us, they trust us. You may not know us, but you'll like us and trust us, and we'll effectively defend your insured for the E&O portion of it. The reality is when you have a claim like that, where it now then falls on goes back to your E&O coverage, okay? Your carrier is going to go out and hire you an attorney. They're going to provide you that defense portion of everything, okay? We're, making sure you have these good policies and processes in place is the difference between essentially burning through your E&O coverage that you bought, okay? And, if you don't have all of these processes in place, and it's kind of like everyone has to dig through everything, should you have a process in place where all you have to do is press a button and everything is neatly organized and emailed over to your attorney? Or is it better to be like, well, here's a box of, for lack of a better term, box of crap. You at $350 an hour can go dig through it and figure out what is relevant, what's not, and then piece that all together to create a defense. the latter is better. The former is better, the latter is worse, because with your E&O coverage, you only have a certain amount of coverage at the end of the day. And you can burn through that. Attorneys range from 250, 450, $500 an hour. You can burn through that relatively quickly and essentially get you had E&O coverage. Your defense has already burned through it. Enjoy, you're on your own, letter from your carrier. So it's not a matter of like when you hire the attorney, it's a matter of once you've hired or once your carrier has hired the attorney, or you initially start off trying to hire an attorney to essentially get yourself out of the litigation, before it becomes big. And then transitioning from that to where the carrier has now picked up the bill, or is picking up the bill for your defense. But it's really about, do you want to do you want to essentially be proactive on the front end and make sure that you've documented yourself and you can actually put together, say, a defense like, hey, you know, the insured claims that, oh, well, I never got notice that I didn't have coverage. And you can go back to your record and be like, I called you 45 times before that policy expired. What do you want me to do? Knock on your door and crawl into bed with you until you pay your premium? Like, what's considered reasonable? Or, with a lot of cases where it's like, oh, well, they never notified me that I didn't have enough insurance. Well, here's where it was explained to you in an email, and you were asked multiple times, do you think that's sufficient to replace your structure if it was to burn down? And then once it burns down, it's like, oh, I'm shocked and surprised and horrified. How dare my agent not recommend, better coverage? And it's like, I recommended $100,000 more than what you actually had. I offered you more coverage, you declined. Thanks, to have a nice day. And in those situations, you can get out of it fairly, you know, you early on, if there's a, really clear cut documentation that you probably didn't do anything wrong. You did everything you were supposed to do, and you as the broker or agent, um were not actually at fault for this client being without insurance or being with, not enough coverage, etc.
Yeah. Now, to protect yourself more from situations, obviously the easiest way is deal with the situation at hand and, take out that smoke before it turns into fire. Obviously reach out to the client, try to work it out. But if the client is being unreasonable and are taking legal actions, the E&O coverage obviously would kick in from there, and you're silent. Your lawyer's taking is taking the show, right? Is taking
I
the
mean,
shoulder.
you're not exactly silent, but you're mostly in the background, like,
Yeah, that's
providing
why we hire a
information.
lawyer. I mean, I really don't want to speak for myself because I'm scared of my.
Technically, you have a right. Technically, you have a right to kind of direct it, but the reality is, with our clients, we can give them advice and be like, do X, Y, and Z, and they can choose whether to not to follow that advice
Yeah,
or not. Um,
yeah.
at the end of the day.
Well, let me ask you this then. So if a client has just been okay, so I mean, these situations will come up if the agent is negligent. Let's just be real, right? If the agent is negligent, or knew what they were doing and just did the wrong thing, and they're like, "Oh crap, I got caught,"
Mhm,
or it was negligence where,
mhm,
hey, I was not in the industry I'm still licensed and I got hit with a allegation or whatever the case is, but I'm licensed, but I'm not working at an insurance agency right now. I'm currently doing retail. I'm currently working at software.
yeah.
I'm currently doing anything else. Now, for those type of people, I mean, besides the obvious, take care of it when you can, the obvious, make sure when the DOI calls, you answer and, you get everything done. But what's some legal advice you can give for somebody that has already done all that and has done their due diligence instead of, the negligence. I mean, obviously, it always just comes back to agent negligence, where you get, allegations, or again, over promising, under delivering on a premium or on a product. What other outside legal advice would you give, for people who are like, well, I mean, this wasn't really that messed up of a situation. I don't know why I'm getting this allegation.
I mean, the biggest thing I'd say is, so say you were in the industry, okay, and you leave. You decide, you know what, insurance is no longer for me. I didn't like it for whatever XYZ reason, okay? At the end of the day, when you leave, you need to make sure that you buy a tail to your E&O coverage, because that's the biggest thing you see people who have, say, left the industry and then get hit with. It doesn't even matter if they were actually at fault or not at fault. You end up with situations where people are like, I retired, like I'm done with this. I'm no longer working, I'm no longer participating, like I'm this isn't my thing anymore. Okay, not my horse, not my circus, not my monkeys. Was my circus, was my monkeys, but no longer is my circus and my monkeys. Buy a policy that has a tail. Make sure to buy E&O coverage with a sufficient tail to cover when if those policies you sold, 5 years ago, okay, if one of those decides to turn and go south on you, that you have protection of that. Because I think the worst thing that happens is people who are like, I left the industry, I'm retired. I'm now, sitting pretty, and I have a relatively fixed income based on what I set aside for my retirement. I don't have money to set aside 10, 20, 30 grand to defend myself against a claim from when I was working or when I was active or whatever the case may be. I think that's probably, an ounce of prevention is, worth a pound of cure. Because the reality is sometimes, agents make mistakes. That's why there's E&O, and it's great. But if the E&O won't cover you once you've actually exited, stage right, doesn't really matter. Doesn't really matter if you were at fault or not. You're still defending it. You're still probably going to have to pay something out. You're probably still going to have to do all of that. And how are you going to come up with the money to do that? And that's the biggest thing. So like I know with like a lot of farmers agents, they leave. They get fired, their contract ends and farmers forces them out, or etc. Okay. They don't know what potential ticking time bombs are in those policies that are no longer their problem, but they theoretically could get dragged into some litigation if one of those policies goes south and they no longer have control over it. Buy an E&O policy with a tail. Doesn't matter. Just buy it with a tail. Make sure if you're in, an industry where you have, malpractice, or you have E&O that are potential, exposures like that, buy a policy with a tail. We love to, advocate and, you know, tell people buy as much insurance as you can afford. And then we forget ourselves entirely and completely forget ourselves unless it's the end of the year or end of the quarter and we need to hit our numbers, then we remember ourselves. But outside of that, we forget ourselves for the coverages we actually need in those situations. um and I think that's probably the biggest, kind of proactive advice, is it doesn't matter what you do legally. I mean, other than keep all of the records that you possibly can, um and keep those stored in a database, but like actually buy something that's going to protect you at the end of the day if one of those policies goes awry.
Gotcha. So yeah, um, and I just want to be respectful of your time here. So I guess one of my last questions here is, um, so outside of a client complaining or a client allegation, outside of that, what other legal exposures are there? For example, let's say, you know, with anything with SMS, like texting, or anything that has to do with communication or FCC barriers, or anything that has to do with the DOI coming after your business as opposed to a client coming after, a policy that they felt like it wasn't,
Yeah.
all that. or wasn't up to their, standard or whatever the case was. In terms of like a corporation or in terms of anything outside of that, what other legal exposures are there?
I think the next biggest one, which a lot of agents, and I see this all over the internet, and especially here, we're in California, it's a huge thing here. Okay. It's not the Department of Insurance coming after you. That's, you really have to kind of screw up and really, have, say, unlicensed people working with you for the Department of Insurance to come knocking at your door. Okay. Or be absconding with client funds and not issuing the policy, like the those types of things. That's when the Department of Insurance comes and knocks on your door. Okay. But newer agents or even more advanced agents that have been around for a while, okay, they need additional support staff. They need people to come help. Okay. And I see this every day on the internet where someone's like, I'm hiring someone. How do I pay them? I'm going to just 1099 them. In California, okay, our employment laws are insanely robust. Okay. So if you have an employee and say you hire them to do customer service and you're like, oh, I'll just pay you commission on anything you sell on, after you're doing your customer service, like anything you cross sell, I'll pay you, 90%, 100% commission and incentivize you that way. And I need you in the office from 8 a.m. to 6 p.m. Monday through Friday and like every third weekend and so on and so forth. Okay. Congratulations. You just opened yourself up to a potential misclassification, wage and hour, and a whole slew of employment level claims. And the issue with the employment level claims is that in California, one, they're robust. Our protections for employees are robust. You need to pay them overtime. You need to pay them for, you need to provide them with their meal and rest periods. And if you fail to do so, if you're like, oh, it was really busy, skip your lunch, leave a half hour early, congratulations, you did another violation. And you see a lot of this where, people go on the internet, they give advice from someone who's outside of California, or even some people within California, but they get advice from, the friend of a friend of a friend. Oh, you can totally 1099 them as long as they're commission only, or as long as they're doing X, Y, and Z. It's significantly more complex than that. And I think the biggest thing that people miss is that they, instead of, I want to say, consulting an expert, they go on the internet and they think that that's their expert, that's where they can get their expert advice from other business owners that have, gone through the same thing. And the reality is that, one, a lot of people don't know what they're talking about. Two, um, that they can't set things up so that can pay people how you want to pay people. Okay. So if you want to 1099 someone, you're perfectly able to do that. The issue is you have no control over them at that point. Okay. You can't tell them when to come in. You can't tell them that they need to be in the office from 9 to 5. You can't do, a whole slew of things. Okay. You can 1099 them, but they need to be able to go out on their own, set their own hours, find their own clients, so on and so forth. Okay. And there's multiple balancing test. Okay, so there's the ABC test, which came out of the Dynamex decision, which then was codified into law by AB5, which then was further changed because they then carved out an exception for in licensed insurance. If you hold a insurance license, there's an exception that's carved out under AB5 for you. Okay, that doesn't mean that, well, now it doesn't apply. What it does is it goes back to the Borrello test, which is a like 13 item balancing test as to, is this person properly classified or not? It has absolutely nothing to do with what the IRS says. It has nothing to do with what the internet says. We're going by a balancing test of what is that person's day-to-day activities. Okay. And the real risk here is, so say you, decide to roll the dice and just do it. 1099 the person, go about it and do something wrong, do it incorrectly. Generally, if you get hit with a wage and hour suit, people are like, oh, I have EPLI. Well, EPLI doesn't generally excludes wage and hour claims. So if you get hit by a wage and hour claim from a former employee that's disgruntled, your um your EPLI coverage isn't going to kick in. It'll kick in for things like sexual harassment, age discrimination, things like that. Okay, that's when it will kick in. But for um your wage and hour issues, which are way easier to get caught up in, you're gonna have to hire an attorney. And the way the law is set up is that if even a dollar is paid out towards that wage and hour, you're now on the hook for all of the plaintiff's attorney's fees. At a minimum, it could cost you $150,000 to defend one of these claims. It is extremely, extremely expensive litigation. It is extremely costly. Okay. And in certain cities like San Francisco, they are even more aggressive. Los Angeles can be more aggressive, but San Francisco is really aggressive about, wage and hour issues and things of that nature. Um, and the reality is that if you're hiring people, you need to consult with an attorney before you hire that person, before you add them to your payroll and get that set up, because there are certain things that you also have to have set up, like a employee handbook, and you have to have other, things, and they have to sign it. And there's a bunch of requirements once that person's hired and onboarded as to how they need, things they need to do to make sure that that employee is properly added to the payroll. Um, and you need to consult with someone to essentially create a pay plan for you to make sure that they're properly classified, to make sure that when you hire them, that they're, all of the ducks are in a row. Um, and people are like, oh, well, I don't have money to do that. Well, do you have money to pay $150,000 in legal fees once you get sued, or shut down your entire business and walk away because, well, c'est la vie, I did this wrong. Um, and that's I want to say that's probably the biggest thing I see, especially, in Facebook groups that are not just California, but are across the nation, of like, how do I hire and pay this person? And, someone from Texas or Minnesota, oh, just do X, Y, and Z. It's perfectly fine. You're not in Texas. You're not in Arizona. You're not in any of these, very, do what you please states. You're in California. It's a completely different can of worms. And so that, I mean, that's something I can assist with.
Right. And on that topic, just to close out here, how can people reach you, and what what does your firm concentrate in terms of, like, which line or whatever
All
your
things insurance.
divisions?
Literally,
Okay.
if it's insurance related, we generally can handle it. So if
Okay.
you're looking at buying a business, selling a business, we can handle that. We do mergers and acquisitions all the time. If you're hiring people, firing people, we do that all the time. If you're starting a new business, we do that. If you screwed up somewhere on the line and you're getting sued, we do that. Essentially reach out to me. I'll give you, I think you can distribute my contact information. Um,
Yeah,
but
if you could
reach
just put
out
it
to
on the
me.
video, yeah, on the video
Yeah,
here,
I will add it to the chat.
or not
Uh,
to chat necessarily because it's going to be
um,
on YouTube here, but what's a good number or email to reach out to you at?
my direct line is 626-818-1463. And my email is my first initial followed by my last name at Stone, STONE, Dean, DEAN, law.com. Um, but reach out, like when in doubt, reach out, because it's easier if it's something where it's like, you're good, reach out to me. I'll happily talk to you. Um, run your question past me. If it's something that you need to hire someone about, we will, our rates are fairly reasonable, and we'll figure out, payment from there. If it's something that's easy and like 3 seconds of advice and go forth, it's a free consultation. Don't worry about it. But when in doubt, just reach out and ask a actual expert. And if it's not something we can handle, we have a enormous network of attorneys that might be able to assist with it, whatever the issue may be. Um, and happy to provide, again, if it's not in our wheelhouse, perfectly fine. I'll find someone it is in their wheelhouse and refer you over to them.
Yeah, I mean, I found, having a business lawyer is going to be very important, especially if you guys are incorporating and you guys are switching
Hmm.
from uh, being a sole prop and just knowing that and then switching over to an LLC. Definitely consult a lawyer. But yeah, Patricia, it was good having you on here, and I appreciate the legal advice that you were giving out to the agents and the agencies out there. Wanted to make this video for both perspectives. So appreciate you agreeing to be on here. And yeah, if anybody wants to hit her up, you have her contact number, just press rewind and then you'll find it there again. But thanks again, Patricia, for joining. And hope you guys have a good day. You guys please like and subscribe so that we can have some good content here, diversify our content, obviously, like we're doing right now. And we'll see you at the next one. Thanks.
Thank you.